Good morning, everyone. Welcome to our Professional Advisor Series webinar. My name is Sharon Capetta. I am the Director of Development at the Community Foundation for Greater New Haven, and I'm delighted to welcome you along with my colleagues. You are going to see hear from throughout this program, but we're delighted to partner together with Fairfield County's Community Foundation, the Valley Community Foundation, and the Jewish Community Foundation of Greater New Haven to bring this program to you this morning. Our housekeeping items, you can see on the screen. If you're having any technical difficulties, please use the chat function. And we are hoping for a robust question and answer period, so please use the Q&A feature for that. So without further ado, I'd like to get right to our program here. You can see our partner organizations bringing you this program today. And I'd like to introduce to you our presenter, Mr. Paul Hood. I invite you to read his bio, which has been provided to you. And what caught my eye, actually, Paul's done an incredible number of things and served in an incredible number of roles. But what I think is most interesting to me this morning is the line in his bio says that Paul is able to see through complexities, explain difficult and boring subjects in an understandable and entertaining language. And I think in our field, difficult and sometimes boring subjects do come up, and having them explained in an understandable and an entertaining way is really a great thing. So without further ado, I'll introduce to you Paul Hood.
We got to unmute. We got to turn on the video. And we've got to share the screen. There we go. All right. Need a quick bit of, okay, it says y'all can see my application. Can y'all see it?
Yes.
Yes.
Okay. All right. Okay. All right. Our title is what was sent to y'all. It's not Ozzie and Harriet. Obviously, that immediately identifies me as old. But our subject today is about the modern family. And the modern family today is quite different from what many of us at least, not all of us, but many of us, believe was the, quote, traditional family. There's some evidence to the contrary for that socially, but the bottom line is that since the 2010 United States Census, all right, since then, the blended or step family, and I'm going to talk about those two terms in a minute, and what they mean and possibly don't mean. But the bottom line is that the blended or step family is the most common form of family unit today in this country. And there's very little written about planning for the largest family segment, which you might find surprising. I know I've found that surprising, having written on this subject now for close to 35 years. I'm amazed about how little is actually written about it. And I think it's because it's tough. It's a tough area. And that's normally the sign. But in today, if we were going to measure family units today by reference to former United States sitcoms, we could easily argue that Leave It to Beaver and Ozzie and Harriet have given way to the Brady Bunch. And for many of us, the Brady Bunch was our initial foray into what a blended family was without them even saying the words. You know, we had Mike with his three minor male sons, Mary Carol with her three minor daughters, and they all move into the same household. There's apparently no custody sharing going on or part-time residence of the house, which is often a major issue in these things. But the bottom line is that they all moved in together and they added Alice and they became the Brady Bunch. And the title to the book that I wrote, Yours, Mine, and Ours, it is one, and you'll see in a minute, one of the 6 archetypes. I call them archetypes, but they're not exhaustive in the list. Types of blended families. So blended families are quite different in and of themselves. You can't just say, "Oh, I've got a blended family," and then go from there. You got to know what kind and what some of the issues are. We're going to go through a number of things today, and obviously we're not going to cover 196 slides. I really give you the material for a 90-minute or longer webinar. I mean, I've done 3 hours with this deck before. But we're going to talk about some of the practical issues that pop up. And because we have a philanthropy bent in our group today, we're going to talk about purposeful gift planning, a way of life. And I think you'll find that helpful. There's some form language in here, and there's just no disclaimers. It's you take what you get. One of my favorite thoughts about second or subsequent marriage is Samuel Johnson's, which is triumph of hope over experience. Who is the modern family? Well, as I said, it's the most common form. In my book, which is actually the second book, it came out in 2022, in a series of mine called Planning Your Future series. The first book was on buy-sell agreements. It's entitled Buy-Sell Agreements, a last will and testament for a business. But the book I'm writing now is about the fastest growing segment of the couple's population, and that's the unmarried couple. But before we go any further, some people in this field get rather exercised about the word blended. Like, that's an insult. These families aren't blended. There's a lot of fights going on. There's nothing blended about them. And in my personal experience, that's been true, because I have my own blended family. Okay. But the other term, the other option, if you will, the step family, is also often a pejorative or used in the pejorative. So you just don't know. I'm going to use them both. Okay. And I really don't have a preference one way or the other. But what is it? It's where at least one partner has at least one, and it probably should be descendant, has at least one descendant who is not the descendant of the other partner. Okay. That is a blended or step family. I'll let you review the statistics, but as you can see, 113.6 million Americans have a step relationship. The 6 archetypes, the Brady Bunch, we covered. I think we were all familiar with that one. The May-December, which presents some rather interesting issues. One of the most common forms of blended family is what I call the empty nester. And this is also one of the areas where they get divorced the most, the whole issue of gray divorce. People marry 5 years later, like, I don't want this. I'm married at 72, I'm divorced at 77. But the empty nesters usually come together. Their kids are grown out of the house, or they're divorced, or something. And they get together, and their kids often meet at the wedding reception or at the dinner before the rehearsal dinner. And so it creates an interesting family dynamic because they're almost all major age people. We're not dealing with minors or custody issues usually. Eat, drink, and remarry. Another popular form. You've got the same sex blended family, which, despite the fact that the Supreme Court held that gay people could in fact legally marry and be entitled to all of the bliss and misery that the heterosexuals have had a bargain, a control over. They still present some interesting issues even when they're married. So I kept that as an archetype. And then finally, the title of the book, Yours, Mine, and Ours, where two people enter into a relationship, each bringing at least one descendant, and then they have their own. All right, let's talk a little bit about how to work with these people. And these comments, you'd say, well, I'm a development person. I'm not really an advisor. Well, I got news for you. Having run plan giving operations for two different higher ed state university foundations, I'm going to tell you that your donors pretty much see you as an advisor, whether you see yourself that way or not. They see you as an estate planning advisor. And so all these comments, you say, well, maybe ethically, I'm not a lawyer. I don't have those issues. But there are client and personal relations issues that are very, very important. And essentially, there are two ways to work with a couple. One is where, okay, I'm meeting with the two of you, and whatever any of you tells me, I am going to tell the other, or I have the right to tell the other. I may exercise discretion to not do that, but I at least have the right. Or you could treat each partner as a separate client, which I'll be honest with you, ethically, as a lawyer, I was never able to get comfortable with that. So I don't worry about it. There are many very, very conservative, careful lawyers who won't represent any couple ever. Not a blended family couple, no type of couple. One type relationship, one relationship, because there are inherent conflicts of interest in representing essentially unrelated individuals. I mean, marriage is a legal fiction. I believe that before we tell people that we can't help them, that we should look for a way to say yes. I believe that's what most donors and clients want. They don't want to get in trouble, and most of them don't want to be guinea pigs either in a court of law, in an uncertain area of the law. But I believe that we will never go wrong, in my opinion, either as a development person or as an advisor, if we keep what is in our donor clients' long-term best interests at the fore. You pay attention to that, and you do what's right about that. And to be honest with you, you should never have an ethics or another issue. Even if you technically violate an ethics rule, if it was done in the best interests and you have a good reason for doing it, you might not be in a big trouble. Most people want us to help them jointly. Okay. even though jointly is a charged word. And he said, well, why would they want that? You know, they got different wealth and they got different kids, and you know, why do we want to risk muddled advice for people who aren't the same? Well, there are a number of reasons for it, why clients and donors like it. First is obviously you're only paying one set of advisors. And that brings on some synergies and efficiencies of scale. Personally, I am more persuaded by the communication as partners and rather than as adversaries. And I think when both spouses are separately represented, you see this in prenuptial agreements. I wish I had $1 for every prenuptial agreement that I was involved in as a lawyer that I could tell just because of the rancor of the prenup process, which in to a great extent is driven by the lawyers for the parties, not the parties themselves. I am more and more convinced that those marriages ultimately failed because of really wrong-headed advice at the beginning. I believe that in the scenario of a prenup, there shouldn't be a whole lot of back and forth. You know, you each have, and you should be as transparent as possible, make as much disclosure as possible, over disclose, and I used to tell people that all the time, and just be honest. Not try to get over, not try to, hire that. But we have to remember that the default rule is really separate representation. And why is it the default rule? Well, the estate planner or the gift planner is giving that donor or client their undivided attention and loyalty. You're not worried about how it's impacting the other partner or spouse to be intended. The client has total freedom. Now we're going to see in a minute when you work with couples whether you should talk to them individually or separately or both, and you'll see in just a minute that my answer is both. And the reason why it's that is because in my private discussions, people often are at odds with what they just told their partner in the joint meeting. And there's obviously a problem. Now, even the donors or clients who come in and say, we want you to work with us both, there are some signposts that you need to be aware of that may not be the right idea. And the right idea may actually be separate representation for in this particular situation, where one partner is childless. Watch the situation where one of them is the slick, does all the talking, answers all the questions, seems to exert control, gives negative body language when the other person says something or shrugs them off or disregards them or tells them they're wrong. Length of the relationship matters, in my opinion. Number of past relationships, ease of entry and exit, age disparities, disparity in wealth or income, economic dependence. Now, this is one that some people argue with me about, and I'm going to make my case here. I always took the belief that if a couple showed up with a prenuptial agreement that they signed when they got married, we know from the standpoint of legal ethics that, and it's not expressly prohibited as a concurrent conflict of interest under Rule 1.7 in most states' ethics rules. 49 states and Guam have enacted the American Bar Association's model rules of professional conduct. And those are the ethics rules governing the bar. California has its own rules, but they're pretty similar. Okay, and obviously with good reason. But you cannot, in a couple of states, expressly represent both couples or both partners in the confection of a prenuptial agreement. Can't do it. It's unethical. It's a conflict of interest from the start. Watch out also where information is off limits. You know, I have this with my kids. Be very careful about that. Another reason why I'm hesitant about the prenup is it is one of the most common contested contracts in the law. I know divorce lawyers that when they hire a client and they're going to sue on behalf of their client for divorce, if there's a prenup involved that doesn't help them, first thing they file is a motion to set it aside for undue influence, incapacity, fraud, you name it. So knowing that sometimes people get a little control oriented around prenups. You hear the so-called shotgun wedding, with the prospective father-in-law overseeing the marital ceremony with his trusty shotgun in his hand in case future son-in-law decides to bail. He's going to be leaving in a hail of bullets. But the bottom line is that the prenup is often a target. And another thing to remember is that subsequent relationships last shorter period of time than first marriages. For women, it's over a half a year difference for the second marriage as opposed to the first. Men's not quite that much. But the bottom line is that even when people have prenuptial agreements, a lot of times that they identify separate property they haven't kept separate. And that gets into an issue called commingling. And it can be a real nightmare. The bottom line is that whether you're an advisor, a client, or a representative, or a gift planner, in the area of modern family estate planning, you got to be defensive because those waters, that storm can brew in a hurry. I mean, you're talking about sitting out on a big lake, and as you can see, y'all don't know this, but this is the lovely scene this morning from Lake Erie. In my video, I know y'all know that's not true. Sylvania, Ohio does not, in fact, look like this. I wish it did, but it doesn't.
Hey, say, Paul?
Yes.
I don't know if you can hear me. This is Sharon Closius. We have a question.
Yes.
And it is, do you think it would be wise for the attorneys now to actually partner with an outside third party, like a counselor, that can meet with the couple to discuss these things ahead of time so that they're not using such attorney hours to do this work?
Well, I hear you. I think that, and I will tell you that since I agreed to make this talk, at when I did agree to that, I was a vice president with Thompson and Associates, and I've since resigned because I just didn't have time to deal with it. But that is in fact what Thompson does on behalf of its charity clients. It helps the charity's donors while maintaining confidentiality, so the charity doesn't find out what the donor's estate plan. But they get really solid charitable or philanthropic estate planning help. Sometimes in these situations, and quite often, many of these situations, there's a business involved, and I often get involved with family wealth psychologists and family business advisors on the psychology side. And I actually worked some on that side myself. So, in other words, I'm not the lawyer. I'm more managing the transition, the touchy-feely aspects of that. I think the bottom line here is that if you don't have your own blended family, you need to stop for a minute and put yourself in your donor or client's shoes. Like, what would I be thinking about if I were them? And I think the first thing you'll conclude is that there are some tough choices that have to be made. Now, sometimes they're made harder in the old mountain and molehill kind of thing by the donor or client than they actually are. They're just fearful, and they're like, no, I don't want to fool with that because this is the problem. But a lot of blended family clients believe that they're being asked to pick between their biological descendants or their adopted descendants and their current partner. And as you can tell, I mean, that's if it's one or the other, I mean, that's not necessarily good. So, all right, the initial meeting, I'm going to blow through some of this, but just know that you need to pay attention to how blended family couples come to you. As I said, I meet with both partners together and separately. And in fact, I use when I was a practicing lawyer, a two-step engagement letter process. And I actually do a webinar on drafting for blended family planning. And we actually go through that engagement letter where it's a two-stage process. They hire me first to figure out if I can help them jointly. And then if I can, or even if I can't, if I can only represent one of them, the terms of the second representation. So never, ever meet with just one blended family partner. You know, sometimes we do this for our single relationship couples, and even that's a mistake. But in the blended family scenario, it's a big, big mistake. I was involved about 25 years ago, I guess. Yeah. In some multidiscipline psychology, psychiatry, law, analysis work done on some of my consenting clients with psychologists and psychiatrists. And in that research, I identified 11 different fears that these clients, and these were clients of mine, okay? So this was work that was done after their plans are in place, okay? Now we're talking about the process of getting the plan in place. And the process is very important. And the process impacts the final results and the effectiveness of it. But many advisors, gift planners included, believe that donors and clients don't like to deal with estate planning because it forces them to focus on their own mortality. And everybody says, well, they procrastinate because that's why. Well, I wish it was that simple. But as I said, I identified 11 distinct fears. Believe it or not, included in the 11, they're fearful of us. And they're fearful of the process itself and losing control of it. And the only way that, given the disparity of information and authority between the estate planning lawyer and the lay client, the only control they have is to just not do anything, just not sign anything. I'm okay as long as I don't sign anything. And since this work was done, after Hurricane Katrina, I moved actually to the Napa, California. And when I was out there a few years, and I wasn't practicing law, but I started to notice that there was probably a 12th fear that hadn't popped up in my research with the. I think we analyzed, it was either 33 or 39 of my clients, and these were extensive clients. These weren't just people coming in and do wills. Okay, this is family gift planning. I think 40% of them had charitable, either a lead trust or a remainder trust or both. So this is pretty extensive planning, big gifting, evaluations done, that kind of thing. Well, what I didn't find in Louisiana, and it's in part because of our streamlined probate process, people don't care about probate because you can open and close a succession in Louisiana in a day. It may not be advisable, but you can do it. And in most states, the probate laws are streamlined. But we have this history of what I call the parade of horribles. And Norman Dacey wrote a book and got rich called, Avoid Probate with Revocable Trust. And probate got developed into this boogeyman, and state legislators start reacting to that and start streamlining the process. Most states today have what's called, as an option, independent administration, which means you don't have to go to court for everything you're doing. You may not have to go to court at all. And I realize in California, their probate laws are they're shockingly bad. I mean, I've represented legislators in probably 15 or 20 states drafting legislation over the years. And I'm just not sure that the California probate system isn't the worst in the world. So people avoid it like the plague. And they have this fear, even if it's not a big deal, other than in California. They're like, I don't want any part of that. I don't know what it is. It's probate. And if I don't want to be involved in it in any way. Okay. In the blended family, if the couple is unmarried, you got a real problem. I mean, like I said, I'm writing a book about estate planning for unmarried committed couples right now. And here's a pretty common scenario. One of the couples becomes incapacitated due to a health issue, and they didn't have powers of attorney or wills or anything. And the family of the incapacitated person was able to shut out the other partner. And you got to remember, on the healthcare side, remember, protected health information, PHI, from the Advanced Care Directive. Hospitals and healthcare providers can't talk to you unless you have written authorization. So they're out of luck, and I think that's an unfortunate thing. Why is there so much angst in blended families? I think it's all based on fear. You know, people. One of my favorite quotes, and I'm a quote guy. One of my favorite quotes was by Machiavelli. And Machiavelli in The Prince, which of course he wrote for a job that he didn't get. He was angling for a job with one of the Borgias, and it didn't work out, or the Medicis, and didn't work out. But he said, a son can withstand the loss of his parent, but the loss of his patrimony, his inheritance, will drive him to despair. And if people think you're taking what's theirs, there's going to be some unhappiness about that. So that's why it's important.
Excuse me, Paul, this is
Yes.
Joe.
Yeah,
I just
Joe.
wondered if you could talk a little bit more in your experience, how you've dealt with those fears that your clients have brought to you. What are some of the tactics that have worked well for you? Because I think that's a very important point. Sometimes we can have all the logic in the world in our process, but when it comes down to it, it's a very emotional decision, a lot of this planning. So I'd love to hear how you've approached that in your career.
Well, that is a daily problem, and an excellent question. From my standpoint, I think it's important to always, and I do this in the book when I discuss the 12 fears, because I do that. I forget where I did it, but in the book. The book has 3 parts: the basics, blended family considerations, and then technique planning issues. And I think what's important is that that you do 2 things. First is you pay attention to Dr. Stephen Covey's second habit. In fact, you never lose it out of the front of your mind. You need to plan with the end in mind. Where do you want to be, and is the planning going to get you there? It may start you there, but does it get you there? And that's a question that you need to ask. But when people, like, for example, let's say the fear was, I don't trust my estate planner. Well, okay, I hear that. The person hasn't earned your trust yet. But how much do you trust the legislators who voted on the intestacy laws in your state? Do you think they have any idea about your family and how you wanted to see things handled? Let me ask you this. Is it more rational to try to solve the problem than to simply say it can't be solved when it can be? And I guess the bottom line is that you have to keep it. You have to stay in the lanes of rationality, because a lot of these fears ultimately are irrational. I mean, they have a legitimate basis for the fear, but it's irrational given the options that they have. And I think that's what's most important. But you need to figure out what their fears are. You do need to figure them out so that you can address each fear individually. Because a lot of times, if you don't address every fear of a client or donor, they're not going to do anything. They're simply not going to act. So All right, let's move on. We made the comment about, all right, conflicts of interest. Conflicts are always, they always look worse in retrospect than they are. My ethics professor at LSU, the late great Warren L. Mingus, who practiced law for 32 years before he became a professor, and was a brilliant academic, but really a great teacher. He used to say, in a free case, a lawyer can spot a conflict a mile away. But in a fee, just pull that R out, in a fee case, the lawyer may miss a conflict that's sitting on the bridge of his or her nose. I'm not going to take you through Rule 1.7. Know that these cases pop up, and I've given you a cite to a blended family case, Sindel versus Gibson, Dunn, and Crutcher, which is about as bad as it can get. And then a case that came out fairly recently in the tax world called Smaldino, and I raised some questions. I wanted to get to this purposeful gift planning that Liana and I talked about when she first asked me to speak. I believe that as planners and advisors, we should first adhere to the Hippocratic Oath. Yeah, the one that applies to healthcare professionals. First, do no harm. You got to understand that a lot of the planning that we do, in fact, harms somebody in some way. And the first thing we should always focus on is, am what I am about to advise my client or donor to do, is it going to harm them or somebody else? And is it reasonably foreseeable? I believe that donors need to be viewed as the long-term golden goose of your organization. And what I mean by that is, a lot of times clients and donors will act inconsistently with their own best interests, because it's not just altruism and philanthropy that's involved. There's peer pressure. There's a number of other psychological factors going on. And sometimes as a gift planner, I know I've encountered it, and maybe many of you have too. The donor wants to make a gift that is bigger than you think they should make, given their current financial situation. The problem is, if you're like, well, wait a minute. Well, the organization needs to maximize the donations. Maybe. In fact, I'd suggest you the answer is actually no. Because if you get a gift that is too big, and the donor ultimately realizes that, they end up with something called donor's remorse. And if you've never read about donor's remorse or experienced it, and I've both read and experienced it, it's not fun. And it can get you fired and sued, and both. And I believe that if we look out for our donors' long-term best interests, even if it doesn't maximize our revenue today, I believe that you're in you're in the best shape you can be in. Why? Because, as I said, our efforts can be construed after the fact as being selfish, self-centered. And some of these cases, I could name any number of them on the charitable side. But when it involves a fight between a family and a charity over a decedent's estate, the best boss I ever had, and that includes Vern Snyder, when he was my boss at the University of Toledo Foundation. Vern was a better boss to me in a little over 2 years than I was for the 25 plus years I've been my own boss. So, I mean, he was really an incredible boss. But Vern used to say, when the proverbial S hits the fan, development's in the front row wearing white suits. And he's right. He's right. Because immediately it looks like, oh, the charity, they were overbearing. I think of one case, a lady lived in a New York hospital for over 10 years. And why is a development person visiting her every day? What's the reason for that? They're not related. What's going on there? And it's easy to set that aside. Most of the time in the human dynamics of this, the continuum of control is critical because people are looking for various levels, whether it's control over cash flow, control over ultimate disposition, control over the terms. And I divide the transfers into rungs. First rung is simply don't do anything until you die. And that certainly maximizes your access to capital, because that's the biggest mistake that people make in lifetime planning is they unsafely compromise their access to their necessary capital. But is this the best thing? Well, if you wait and you do everything at death, obviously you're not caring about the income tax deductions that charitable gifts give during lifetime at all. And then there may be some exemptions and exclusions for estate and gift tax purposes that may not apply. The second rung is really where people create an entity, family limited partnership, an LLC, and they gift interests in the entity, not in the assets. So they have full control over the cash flow from the entity to the various owners. And that gives someone who has the control, within the confines of state law fiduciary duty, you've got control. The third rung is the private foundation, which you're taking the money out of your private piggy bank and putting it into a public piggy bank. You control it, but there are limitations to it. And obviously private foundations have lower deductibility, contribution-based limitations. And then they have all the private, benefit and private annulment prohibitions against self-dealing and jeopardy investments and, the whole bit. But in the private foundation, the family that wants control, they got it. They ultimately have full grant making responsibility. The fourth rung is a supporting organization, and y'all probably have some up there. I'm not going to, in the interest of time, I'm not going to go through it. The last is the donor advised fund. And that's where the donor gives up not only asset control, but ultimately say so. I mean, you get advisory privilege. Look before you leap on lifetime planning. As I said, don't underestimate the importance of access to capital. Do no harm. One of the problems with charitable lifetime planning is sometimes it's illustrated as showing a benefit to the family, a financial benefit. And I'm going to tell you that I've been looking at these things for 35 years, and I have never seen one that actually worked out that way economically. Okay? The charitable gift is real. And that allocation of assets to the charity is real. Okay? So to argue otherwise, it really makes no sense. Okay.
Paul, this is Lisa Stanger. I have a question.
Yes, Lisa.
So back to the sort of the relationship with the attorney and the client. I mean, an attorney has to zealously advocate for a client's position. How much, let's say, you know, you've got a client who wants to write one of their kids out, who wants to leave to the stepchild or leave out the stepchild, or doesn't consider the adopted grandchild worthy of, you know, a family gift. How much should you, if that's what your client wants and there's nothing illegal, how much should you really talk to and advise your client about it being wrong and the issues that it might cause in the family and why they're doing it?
Well, I believe it's imperative on the estate planner to do that. And the reason why is because estate planners have been sued after their client died for giving advice that led to the problems that were presented in a court or somewhere else. So I think that when you, and it's a real simple thing. I mean, you know, if your donor wants to make a gift of their estate to less than all of their kids, they need to know that that is a potential problem situation. And now, you've got people on the flip side who, even though they could justify cutting a kid out, they believe that inheritance is a moral right. So you have both sides of this. I think that if you're going to be a counselor to your client or your donor, then you need to counsel them on the impacts and the implications of their decisions. Because I'm going to tell you this, and this is on my website, paulhoodservices.com. There's an article that I wrote for Trust and Estates magazine, probably 5-6 years ago, I guess. I forget. And I don't like the title they gave it, which is why I don't really think about it a whole lot. 32 core principles. But it was essentially my beliefs and philosophies about estate planning. And it grew out of an episode where I was challenged by a 93-year-old to give her my last best advice. And she asked what it was. And I didn't have an answer. I had to talk my way into an answer. But what I told her was, your estate planning decisions are going to impact the relationships of those who survive you. Now, those impacts can be positive or they can be negative. Now, you need to know that your decisions, you say, well, that's their problem. No, you're actually creating the problem by not acknowledging that your decision has a hand in it. I think that's important. And I think the bottom line, Lisa, is that this is why charitable intent on charitable gifts is so important. It's mission. It's just absolutely mission critical. I'm not a big fan of the advisors that say, well, this is something that the client really can't afford not to do. Be very, very careful when you've got the hubris to say that. Because I believe it's wrong and it eventually will get you sued. You do not want to make that determination for their client. Estate tax savings is difficult to quantify. And I've done some things like gone back and looked at estates where we did planning in the late 80s, early 90s, and we were projecting this, and this. And in 2011, we see that, well, we missed it bad. I mean, really bad. And I think the bottom line is that is that I'm never comfortable justifying any planning on transfer tax savings. I just don't. Carol's my ex-wife's aunt. She was a psychiatric nurse, and she was a character. She died in her 90s, and Blanche used to say, "When in doubt, sit it out." And I think there's some relevance there. We've got 5 minutes left. I think that in planning, hitting the sweet spot of the 3 factors and fit is what is really most important. Abraham Maslow, the father of modern management, Maslow's hierarchy. He has another one of my favorite quotes, which is, "He who is good with a hammer begins to see everything as a nail." And you see planners like that. They develop an expertise in family partnerships, and next thing you know, every client they've got has a family partnership. Was that really the best for that in every one of those situations? I'm not sure. I think that the bottom line here is mythical Sergeant Phil Esterhaus, when he did the roll call on Hill Street Blues every week, used to end it with, "Let's be careful out there." And I think that's what you have to do. The rest of the materials, the funeral, there are a couple of things that get administration of a blended family estate off to a terrible start. And the failure to plan the funeral and the memorial and the obituary. Oh my Lord, I've seen knuckle junction in obituaries. People just leave out the other side of the family or disparage them. Because remember, the newspaper, they're getting paid for that obituary today. The longer it is, the more money they make. And they don't always read them for causticity, if you will. I used to have help clients write their own obituaries in particularly blended or caustic family situations. Financial powers of attorney, there's some interesting dynamics in powers of attorney in general. Like I said, marriage contracts, pretty common. But you need to know that they're pretty hotly contested too. Let's see if there's anything else that I wanted to, in the 2 minutes we have. There's a pretty good discussion in here on the of a family business in a blended family context and who should be the executor and these things. And I will leave that to you. Life insurance is a great tool for blended families. If you've got the right kind of life insurance, and that's part of the problem. Let's see, portability. I go through some portability issues. Lifetime Q-tip. We don't see many of those today. You start to see some of the forms. There's a Q-tip issue, and I've drafted around it. Spendthrift trust provisions need to be modified in blended family estate planning documents to permit them to be separated from each other, and a spendthrift clause can cause real problems there. Joint tenancy is probably the most common form of mistake in a blended family context. Gift splitting. Estate tax apportionment, I'm not worried about that because most people don't pay it. Tangible personal property. This is the last thing I'm going to talk people will go to the Court of Appeal over the family portraits and grandma's china and Meemaw's crystal. And that needs to be very carefully addressed. And where it often comes up as a problem is in the power of attorney when a step parent is the agent and they start giving away the children's pictures and stuff like that to other people and China, and oh wait, mom said I was getting that, and all of a sudden they don't get that because the agent, their dad's incapacitated, but the stepmom is making decisions as the agent. So with that, let's continue the discussion. If you have questions and we don't get to address them here, please email me. I do recommend that you look at my website. I have a number of things there that I try to give people stuff to help them with. I want to thank the 4 organizations for inviting me. And I want to thank you for your attention and your decision to attend today. I hope that I said something today, at least one thing, that helps you help one of your donors or clients today. And thank you very much.
Well, thank you, Paul. We're delighted that you joined us today. And as there was a question about the materials from today, and individuals will be able to get the deck that if they attended. So we will send out a summary and a link. And I would ask attendees, please, if you wouldn't mind filling out the quick survey that you'll receive. It would be helpful for us in planning future programs. Thank you again to our partners, the Fairfield County's Community Foundation, Jewish Community Foundation of Greater New Haven, and of course the Valley Community Foundation. Thank you all for attending, and please do reach out if we can be helpful. Thank you.
Thank y'all. Go Tigers.